I'll be your conference operator today. At this time, I would like to welcome everyone to the Are You Ready for TCPA Compliance conference call. All lines have been placed on mute to prevent any background noise. If you should need assistance during the day's call, press *0 and an operator will come back online to assist you. Thank you. Mr. Henry Dancer, you may begin your conference.
Thank you, Melinda. I appreciate that. Hello, everyone. Welcome to the TCPA compliance call. I'm going to be the moderator, and let me start off with a few housekeeping items here. I'm going to introduce myself first. As Melinda said, my name is Henry Dancer, and I'm with Noble Systems, and I'm the Western Region Vice President. So my responsibilities within Noble is covering the western half of the United States for my customers and clients, and I've got about 35 years in the contact center space. Before I introduce the rest of my team here on the call, I'd like to just go through a couple of things. We had an overwhelming, this is really positive, an overwhelming response from everybody on questions and sign-ups. So we had way over 100 people send in questions and whatnot. So we're going to get through as many as we can. So we do want to be respectful of everybody's time. We're planning on being on the call for between 45 minutes and 60 minutes. For those of you who questions we don't get through, don't be worried. We are going to do a couple of things. We're going to have a second session. We're looking to do that in December. With David as well, who I'll introduce in a minute, as well as we have other areas of, and plus we're also going to answer all of the questions that have been submitted and get them back to you for the ones that we don't get through in this hour session. So like I said, we've got a lot of great questions and a lot of enthusiasm on this, so we're going to get through as many as we can. As Melinda said, please mute your phones. That helps a lot. If you have questions that during the course of the session, please, you can submit those also via the toolbar. So if we have time, we'll go through those as well. If not, we will, like I said, we will answer those questions for you as well. And the last thing is for those of you who are Noble clients, SNUG, which is almost a little plug in there for SNUG 2014. It's going to be in April down in Florida again, and we're going to extend our compliance sessions because once again we're seeing a tremendous need and desire to spend some time talking about this topic. So. We're going to focus on that quite a bit. So anyway, now to the introductions. I wanted to, two people I want to introduce that are going to be driving this, at least a lot of this portion of it. My cohort on the Noble side is Howard Leary. Howard's a Strategic Solutions Director with Noble Systems, and he brings over 15 years of working experience in consulting with companies and government agencies to leverage technology and solutions to solve their pressing business challenges. So, Howard, can you maybe speak for a second? And that way people can kind of tie the voice with the name.
Sure. Thank you, Henry, for that introduction. Just to provide some additional background, I've in those 15-plus years of contact center industry experience, I've served as a solution consultant and technology strategist for many well-regarded companies. As a Strategic Solutions Director here at Noble Systems, I help us to identify and address relevant and emerging technology trends, business applications, and contact center industry regulations. And then my principal role, of course, is to help us to gain market share through the application of our existing capabilities, and then to address any novel business challenges through innovation. Henry, back to you.
Thank you. And our featured speaker today is David Kaminsky. So David is actually out of Southern California, as I am, which is a treat. David specializes in the defense of collection agencies and creditors under the Fair Debt Collection Practices Act, FDCPA, that's a mouthful, and the Fair Credit Reporting Act, the FCRA, and the Telephone Consumer Protection Act, with the TCPA, which a lot of us are talking about right now, as well as related consumer protection statutes. He represents clients throughout the United States and practices in all states and federal courts throughout the state of California, as well as the Ninth Circuit Court of Appeals and the California Supreme Court. Mr. Kaminsky has extensive experience in multi-district and class action litigation with emphasis on TCPA, FDCPA, and FCRA. They just roll off the tongue, those acronyms. I love that. The state, as well as State Invasion of Privacy and Recording Act and the California Business and Professions Code. Mr. Kempinski is a member of the attorney panel of the American Collectors Association, the ACA International, and has been retained by the ACA International to coordinate defense strategies in the TCPA class action lawsuit. So, David, we're all duly impressed. Can you maybe introduce yourself, and we can hear a little bit about, more about you from yourself. Uh-oh, David.
Yes. Hello, everyone.
Okay. I was sweating bullets there for a second. Our featured act wasn't going to show here.
Hello, everybody. Thank you so much, Howard, and it's a pleasure to have you all on board. I don't think I need to give you any more information about myself, just that I am fighting all the time for the debt collection, the credit industry, the banking industry, the telemarketing industry with respect to these ridiculous and draconian TCPA rules. Unfortunately, many of these rules we are stuck with because they are final orders, but we're going to do what we can, of course, to educate you on them and how we're fighting around the rules and what we can do to comply with them. So with that, Howard, take it away.
Well, this is Henry. Let me just start this off. David, as you can well imagine, we received a lot of questions from the attendees today on the call, and maybe my first question here is how to stay in compliance with the new TCPA regulations, especially in modern society where many people no longer have landlines. So can you kick off a few general comments about the TCPA law and how the regulation affects various industries, whether it's collections, telemarketing, or nonprofits? So
sure.
Maybe David and Howard, I kind of give that back to you.
Sure. The TCPA, unfortunately, is regulating not only just about every industry today. Unfortunately, dialers, as we know, were not supposed to be interpreted as they are being interpreted currently. There's been such an expansive interpretation of dialers by the FCC, and sometimes now by case law, we're following some of the FCC's interpretation that so many different industries are being brought into the fold of the TCPA. Every industry is being affected right now. I can't think of one that isn't. And recently, when Emotion had requested the court to make a categorical exemption for a particular industry, the court said when you read the plain meaning of the TCPA in the plain language, there is no categorical or general exemption for any given industry. Yes, there are some specific exemptions for certain activities under certain exceptions, but there's very little categorical exemption for any industry. Every industry is being brought in the fold. The banking industry, the credit industry, the collection industry, as you know, they're fighting the FCC day in and day out. The cargo industry has been. The healthcare industry is even affected by this. And, of course, the telemarketing industry. So it's very hard to comply, but unfortunately you have to have a compliance protocol because this is the law. We're stuck with the law, and that's what I work with clients constantly to develop a compliance protocol because you have to stay in compliance because the majority of all the calls being made today are being made to cell phones.
Okay, well, let's talk about that and some of the new rules and regulations that are coming up or that have come up here in 2013. Can we get into some specifics?
Sure. As most of you know, the October 16th, 2013 rules have come into play, and unfortunately, the old rule was that if you had prior express consent either in writing or orally, you had prior express consent to call someone on their cell phone via automated dialing equipment. Unfortunately, that's all changing right now. And the courts are saying, wait a second, the FCC comes out with its new rules as of October 16, 2013. They issued their report as of February 15, 2012, saying that from now on, calls that are being made for telemarketing purposes to cell phones or pre-recorded messages to landlines, you have to have written consent in order to have consent to call the cell phone at issue or to leave the pre-recorded message on the cell phone or to leave the pre-recorded message on a residential line unless you fall within 1 or more of the exemptions. We talked about basically what is telemarketing, and are you telemarketing? Well, basically telemarketing is a call that offers, promotes, or I guess markets products or services. So if any call is conducted to induce the purchase of goods, services, the FCC is going to deem that basically a telemarketing call. Courts are deeming what is a solicitation or what is telemarketing very broadly. And these October 16th rules are very difficult. They're very difficult to comply with. They require basically that you need written consent, and again, it only applies to telemarketing calls. They do not apply, as the FCC has said, to non-telemarketing or informational calls. Basically, the new rules do not apply to debt collection. It's not going to apply to a call on behalf of a tax-exempt nonprofit. It's not going to be applied to a call for political purposes, calls made by a loan servicer regarding just pure servicing, and it also doesn't apply to a health care message. It also doesn't apply to those airline notifications, banks, schools, etc.
That's interesting, because I think one of the areas I see you're talking quite a bit about telemarketing there. I know one of the big concerns that we all know about in the collections world is the Nelson versus Santander ruling, and many of our customers and clients are concerned how binding is that, and how is that rule going to affect them, which is really a collections call. So maybe you can kind of do that compare and contrast between what you just talked about in telemarketing and how that translates into collections.
Sure. So let's talk about it from two standpoints here. Again, if you are, under the TCPA, making a call for, let's say, telemarketing purposes or informational purposes, and you are using a automatic dialing system is defined by the TCPA and by the FCC, which is a very broad interpretation of what is a dialer.
Right.
You're using a dialer to make such calls to cell phones, to leave pre-recorded messages. Then you have potential liability for the written express consent requirements or the general consent requirements. Under either scenario, you have to have consent, whether it's written, whether it's general consent, and that is a problem because many of us know it is very difficult to capture consent, to obtain consent, and to prove consent, especially under the new written consent requirements and, of course, even under the old, let's say, written or oral consent requirements. So then a lot of companies said, well, you know what, we're going to get around this rule. We're going to get around this whole dialer prohibition. And a case came out called Nelson versus Santander, but that case and the order they're on has been subsequently vacated. But in short, what it said is this. It said this, is that defendant basically was using something called preview dial, meaning the account pops up and the account representative is able to preview dial and the account before the call is actually launched by a dialer, and it's the person who's viewing the account who has to click on a mouse or press a stroke of the keyboard in order to launch that call. What happens here is that the court said, well, wait a second, you're using this preview dialing and you're using this human intervention, and I understand that you're doing it to get around the FCC 2008 ruling and its pronouncements on what is a dialer. But unfortunately, you still use the dialer. You use a predictive dialer, and the FCC said, well, that's a dialer that falls into the purview of the TCPA as a prohibited dialer. Therefore, the fact that you were preview dialing is merely a red herring. So the question is, well, how does this case resonate, and how is it going to, quote, be used maybe by other courts? Well, it can't because it's a vacated decision. But could other courts use the same exact logic that that case did and basically find that although you're using preview dialing and you're using this human intervention, the bottom line is that you're using a dialer that has present capacity to fall into the purview of either the TCPA or under the FCC's interpretation of a dialer. Therefore, you have a dialer. Therefore, this preview dialing is not a panacea or an automatic out or an automatic pass under the TCPA, because many courts will say you're still using, quote, a dialer because the call is being funneled through a dialer, which falls into the purview of the TCPA.
So, Howard, I know you're very knowledgeable in this with your clients. So anything you wanted to add, I want to make sure we get your perspective as well.
Yeah, thank you. And that's a very good review of the Nelson versus Santander ruling, and of course how it leaves a lot of uncertainty in the industry. We specifically created a solution to address the Nelson versus Santander ruling, and we call it the Nobles TCPA Wireless Compliance Solution. Now, what it does is it does a pre-call check before a call is launched to determine, number one, if it's a wireless number, if it's eligible to be called based on configurable compliance criteria. After that, we then prompt the agent to pick up their handset and to manually dial the phone number. But before the call can be completed in the PBX, there's still another compliance criteria check where we prevent the call from being completed as initiated by the agent before we do another compliance check. And an instantaneous check is, have you reached the maximum number of attempts? Have you, waited long enough, delayed long enough between attempts? Have you, are you calling within an eligible time zone window, and so forth? And so we'll do all of those types of compliance checks, as well as checking your collections application, your system of record, to see if there is express written consent on file. So once that's flagged in your database, it can be used either in a dialing list or is in a lookup process to determine whether that call is eligible to be processed. So that's
great.
Yes, thank you.
So maybe now we get into some more questions that we've got from our customers. The first one that I had here on my list, I think, David, you've already answered it, unless there's something else you want to add to it. Is there any specific rules around using automated dialers and automated messaging that we should be aware of? I know you kind of hit on that. Is there anything else you want to clarify on that, or should we just move on to the next one?
I'm just in short that with regard to automatic dialers and pre-recorded messages for, so many different industries, unless you're exempt from any specific rules, and we don't have time to get into all the exemptions, but that may be for another session. But you just have to vet your automatic telephone dialers. Number one, please talk to your IT people and make sure that your dialer does not have what the TCPA, the definition in the TCPA talks about, and that is an equipment which has the capacity to store or produce numbers to be called using a random or sequential number generator. So talk to your IT people. Make sure that your dialing technology doesn't have random and sequential number generator technology or programming. That's number one. You also have to look at your dialer from the FCC perspective. Unfortunately, the FCC says if your dialer is a predictive dialer, well, that to them constitutes a dialer under the TCPA. There are fights going on this issue as we speak because we think the FCC went too far. Nevertheless, courts throughout the country, some of them, are following that FCC ruling on the dialer pronouncement. They even go so far as to say, because they're mimicking what the FCC says, is that it is a dialer that has the capacity to dial without human intervention. So you need to vet your whole dialer process, see what you're doing. There are dialer workarounds. There are dialer solutions. And until every single court throughout the U.S. adopts the fact that these dialers we are using do not constitute dialers under the TCPA, we have to do some workarounds.
Okay. And Brad, we're talking about cell phones as opposed to landlines here, but I have another question here, which I find incredibly interesting because I did not know this, and I also am curious, whether this is with cell phones only or landlines as well. And the question that was submitted was, do you have any suggestions on limiting calls to the elderly, especially since the TCPA restricts calls to elderly home or other institutions where the house primarily houses primarily elderly persons? So I guess it's an interesting question. Never even thought about it. So maybe you can get some light on that for us.
That is a very good question. I think whoever wrote that is trying to play Stump the Attorney. Not
it's a good game. I like that game.
This is not a question that comes up frequently, but from what I recall in my understanding, that the TCPA basically prohibits auto-dialed calls, and then you got pre-recorded messages to elderly homes. So it's not to elderly persons, and I believe the FCC has issued some kind of order in a previous proposed ruling saying, look, the TCPA doesn't really define the term elderly homes, but they clarified it. I believe that they said it concerns institutions such as nursing homes, a healthcare facility, things of that nature. It is not going to be a call to quote someone at their home just because they're elderly. So if you're not quote using those random and sequential number generators, which are then going to call any and all numbers in the entire phone book lexicon, I don't think you have too much concern that you're calling someone out at an elderly home. But, of course, you could and possibly get someone, quote, at an elderly home because they're giving you that number as their residence.
Okay. I get that. The next question I have, what's the best practice to identify phone numbers that are on file for some time as cell phones for this new registration? Yeah, sorry about that. I fingered that one. So it was numbers that are on file that are cell numbers for this new legislation. And so I think what we're talking about here is recommendations on new technologies that can help our customers identify and scrub their cell phone lists or phone numbers to see whose cell phones and who are not. So what are some of your ideas on that?
Well, basically, you need to have, because of the law, because of the quote prohibition on auto-dialed calls to cell phones, and because of that prohibition, you need to scrub. You also need to scrub for cell phones so that you're weeding out those cell phones as opposed to residential lines, especially when it comes to leaving pre-recorded messages. There are certain exemptions on the leaving pre-recorded message to landline side, and some exemptions on the leaving pre-recorded message to landline side that you don't have with your cell. So it is critical to get scrubbing technology, segregate your cells from your landlines. Don't call those cells with automated dialing equipment until you know you have consent. That's either written consent other than the new October 16th rules if you're telemarketing or selling, or general consent, oral or written, if you are just an informational or a debt collection call or a commercial call that does not include an unsolicited advertisement.
So, Howard, I know you've been kind of involved in this, and maybe on a real more tactical level. Do you have anything you want to add on the scrubbing of cell phone lists?
Yes, thank you, Henry. One of the things that Noble does is we partner with, a company called Possible Now, and there are other providers out there. But what Possible Now does is it allows you to do a pre-scrub of those records to determine before you ever even send them to a dialer, are they in fact cell phone numbers? And then you can have other processes that go in and as far as determining whether you have express consent to call those particular phone numbers. But we also offer, through a subscription with Possible Now, a wireless list management service that allows you to, in real time, as you're dialing numbers, so if you've got like active lead generation or new phone numbers and so forth that are being entered into the system, that you can, in real time, as you're attempting to dial them, check whether or not they are, in fact, wireless numbers. There are some other authoritative sources out there, again, and so that would be a recommendation that we would definitely push for.
Okay, perfect. Thanks, Howard.
Yep.
This is a very interesting question as well that just came through. It says, what is the best wireless opt-in verbiage required for express written consent? It says, the question comes from someone who says, what the concern is what's the best way for them to get their permission from their cell phone customers when they have 450,000 members? So they see this as a daunting task. So they're trying to figure out what's the best way to do this. So, David, you have some ideas there?
Yes. I mean, look, I believe that the person who's asking the question is probably talking about the new telemarketing rules and the new telemarketing rules that require, quote, prior express written consent. Well, that means certain things. That means, quote, a paper, actual paper, traditional paper consent, and also the FCC said, look, we realize that this rule is draconian and that we're going to allow consent to be obtained versus the e-Sign Act. The e-Sign Act means electronic. You can get someone's electronic signature. And the e-Sign Act basically allows a signature via the email, via website, via text message, via a telephone key press in conjunction with possibly a voice recording. So there's ways to do this. And there is also specific verbiage, which it would be easier if I could, of course, demonstrate it by a slide, but I'm sorry I don't have this with us today. What is the specific verbiage? But the consent has to very clearly make various disclosures. There's got to be certain conspicuous and clear disclosures that's apparent to the consumer. They can't be hidden, and it has to tell the person various specific things that, for instance, they are not required to sign the agreement, let's say, indirectly or directly, or agree to enter into an agreement as a condition of purchasing any property or goods, and that by executing such an agreement for them to call, that they're authorizing specific sellers to deliver telemarketing messages. And you have to tell them not just specific messages, but messages using an automatic telephone dialing system or an artificial or pre-recorded message. This whole written consent requirement and what you need literally could be a lecture in and of itself. I just can tell you that it is very difficult to get. There is the e-Sign Act, which does help you to get it in a various myriad of ways. For instance, if you're using a text message, a good way is to have a text message, but that it redirects someone back to a company's website, because you can't possibly fit all of the disclosures that you're required to make under the new written consent rules in a text message. But the redirect is a great trick, because they click on the link, it takes them to a website, and then you have the full website with the full disclosures, and you can capture consent.
Oh, very, very nice. That is nice.
And definitely within the Noble solution, you would have the ability to do that key press and recording capability, whether it's in the IVR or during an agent interaction. If you wanted to capture that consent, we can automatically start and stop the recording at appropriate points in that agent script as well.
And the next question, I think, kind of ties that together, and I find it very interesting as well, because the question is, are there particular rules that contact center operators should consider when launching robo or blaster calls? And then the question, the second part of that question is there a difference regarding whether the call is made for telemarketing, collections, or even, say, healthcare appointment reminders? So I know earlier in the call today you talked about the different industries, and you talked about telemarketing, collections, and healthcare. So this is interesting. This is really talking about a robocall and, what they have to be aware of in launching those, and what's the differences based on the different industries.
That's a very good question. Actually, it's a loaded question. That in itself could take
a loaded question. I like that.
But let's give you the real short. Yes, everyone knows there is a difference between if the call is made for telemarketing, you need prior express written consent to make that call, generally to a cell phone, or to leave a pre-recorded message on a cell phone, or to leave a pre-recorded message on a landline. Tax-exempt nonprofit organizations, they're exempt from the written consent rules, and they're exempt from the rules that require express consent with respect to pre-recorded messages to landlines. I know that's very confusing, and the whole consent issue of when you need it, when you don't, gets very complicated. Healthcare appointments as well, they're not subject to the new written express consent rules. All of the informational calls, all of the debt collection calls, healthcare calls, tax-exempt nonprofit organizations, they are exempt from the October 16th written express consent rules. However, with informational calls, bank alerts, school closings, etc., those entities still have to have some form of general consent in order to leave a pre-recorded message on a cell phone, or to make an auto-dialed call to a cell phone.
So Howard, anything else you want to add before we kind of get off that topic?
Yeah, actually, we also know that there's some requirements in the law around automated opt-out mechanisms, and so whether it's on an inbound call where they're returning a call and need to be directed to an automated opt-out mechanism, or on an outbound call, we can provide that mechanism through the IVR manager in the Noble solution, and then it can add the customer's phone number to the sellers or to the company's specific do not call list, and then immediately disconnect to stay in compliance there. And particularly on the outbound calls, I think it's important to note that we can differentiate the message based on whether it's a human answer or an answering machine that answers the call. In those particular situations, you can provide a different script or a different IVR flow, if you will, that allows them to prompt one to be excluded, or, for an answering machine, you obviously wouldn't be prompting the customer.
Right. Okay, thank you. Now, this question is kind of taking us a little bit, it still has to do with compliance, obviously, but it's a little bit different. I thought it was interesting. It says, can you discuss the impacts of state and federal laws requiring consent to record the call? Does it matter if there are collection calls, telemarketing calls, or et cetera? So now we're talking about recording and how that's affecting with all this compliance concerns. David?
So recording laws, let me just give you the general. There are 12 states that require something called dual consent to record, meaning you would have to get consent from both parties to the call in order to have consent. In other words, someone would answer and say hello, and you would say, hi, this is John Smith on a recorded line. Is Jenny Smith there? Or words to that effect. And you would have to have dual consent. Some states are unilateral or single consent, meaning if the one person who's recording decides they want to record, they don't have to tell anyone or get the second person or the consent. But California seems to have the most draconian rules in this regard. Some other states do too, but California seems to be the worst because they're imposing their dual consent requirements on states outside of California. So they're saying, hey, states, if you have a unilateral consent rule and you're calling into California, well, guess what? You have to comply with our dual consent rule. They have even gone so far, but this is being hotly debated, that California says when a California resident calls from their state into another state for a business purpose, and they're calling a business who transact business in the state of California, yet they're calling into that unilateral state better know if a California resident is calling, because then they're going to have to give consent to that person. In short, there's so many different state laws on this, and you've got the unilateral consent, you've got the dual. The best way to handle this is that if you do record, just for those incoming calls, have an automated message that tells the person who's calling in that the call is being recorded or may be recorded and or monitored, depending on what exactly you're doing, and the language of that varies. And then if you're calling into whatever state you're calling into, because it's so hard to differentiate perfectly which state you're calling into, because cell phones have area codes, and someone with a 617 area code could be living in the state of California. And you'd have to give dual consent. So if you are recording, it may be the safest bet to give everyone the recorded warning, even on the live calls. Have your agents and train them to do that.
Wow. That answer was a lot more intense, I think, than I expected when I first read the question. I thought it was fairly benign, but wow, there's a lot out there to learn. Howard, I know that there's some things on the Noble system that might be able to help in that regard. So do you want to add a little comment to that, the recording?
Yeah, absolutely. I think in addition to the scripting that can be done at an agent desktop level to prompt the agent for the proper disclosures and prompting of the customer for permission, you also have the ability within Noble to use a recording exclusion filter that prevents the automatic recording of calls, and you can set that at a campaign level as well as filter by state or even area code where that is applicable. So that gives you quite a bit of flexibility in addressing call recording.
Sounds good. Okay, so I'm going to change gears a little bit here. So, David, a lot of our attendees appear to be in the collections or the accounts receivable management industry. So let's talk about the TCPA regulations that impact the collections calls as well as text messages and email communication. So I've taken it and I've expanded it out a little bit. And the first question I have in this kind of grouping of questions, are there any specific steps that agencies should take when contacting for collection purposes?
Got it. And I realize on this call we have some people from the collection industry, from the telemarketing, and we're trying to strike a balance here and give both of you information that could help both of your sides. But on the collection side, with regard to specific steps, for collection is not subject to the October 16th written consent rules. That means that consent can be obtained in two ways, via in writing or orally. Therefore, if you're using automated telephone dialing equipment technology to call cell phones via your dialers or to leave pre-recorded messages, or if you're leaving a pre-recorded message on a landline, because that's the only trigger for a landline call, then you should also, again, use scrubbing technology. Also, vet your dialers thoroughly to find out if you're using a dialer that falls within the purview of the TCPA. And scrub those cell phones from your landlines. Debt collection does fall within the commercial call exemption from the Code of Federal Regulations. That's 64.1200. And basically, the Code of Federal Regulations says if you're making a commercial call without an unsolicited advertisement, you're making up a pre-recorded message call to a landline, you have an exemption there. That same exemption doesn't exist on the cell phone side, unfortunately. And I know there's been a misnomer out there for all of you in the world. There is no general debt collection exemption that I am aware of that applies to calls to cell phones, pre-recorded messages to cell phones, as well as to pre-recorded messages to landlines. It is those exemptions were enacted only with respect to pre-recorded messages to landlines. That's the only place that we've seen so far, and all the cases support that provides the exemption for debt collection calls. So even if you made that pre-recorded message call to a landline without prior express consent, you may likely fall within that exemption, the commercial call exemption, so long as you were not including an unsolicited advertisement.
Now, I know there's some discussion here in the preamble on this with some concern about text messages and email communication. No, it's not exactly the intent of this webinar, but that was in the question. So anything you quickly could address with regards to texts and emails in the collections environment.
Very quickly, email has not been used at all. That falls under it doesn't constitute a automatic telephone dialing system call from what we've seen. Can that change by the way technology is changing? Could the FCC expand the rules? Unfortunately, the FCC is constantly changing and trying to expand the scope and the purview of what is a dialer, but so far right now an email doesn't constitute an auto-dialed call, thank God. But real quick, with a text message by various courts has been deemed to be, quote, a call, as that word is used in the TCPA.
Okay, great. Thank you. Giving everybody a clock check, we're just at about 20 minutes above the hour, so I'm going to kind of go through this, get as many through as I can. So like I said earlier, for those questions we don't get through, we'll set up a second session here in the next few weeks. Another question I thought was very interesting. Can you contact a debtor using a dialer if you are manually dialing the number by actually keying in the phone number? So I know we've kind of talked about this a little bit, but this is a real direct thing. I got a dialer, but I'm just going to manually, I can record the call, you're going to hear it, I'm going to manually hit the 1-213-555-1212. Does that work? Does that help you out?
That's excellent, fantastic question. I think it applies to everybody here on the call, telemarketing, non-telemarketing. Basically, okay. If you're manually dialing, let's say on the standard, what we call the standard telephone set, one that I'm using right now to speak through, and if you're going through what is called your standard PBX, then most courts have said that you're not using a dialer. It all depends what you're going through. There was a case that was very important that said Well, the defendant was using a telephone, and that standard telephone, a desktop telephone, happened to be connected to their dialer. But to make the call, they were not using the dialer. And this is the key under the TCPA. You have to be, quotes, using a automatic telephone dialing system in order to have potential liability for those calls to cell phones or the pre-recorded messages. So using an automatic telephone dialing system is the key here.
So even though you're not dialing in an automated fashion, the sheer fact that the system has the capability is the crux of it.
If the dialer you're going through, if the call is being launched through a dialer that has the capacity to fall into the TCPA or the FCC's definition, you have a potential dialer. It wasn't supposed to work the way that this law, but unfortunately that's how broadly it's being interpreted.
Okay. Now, Howard, I'm sure you've got an opinion on that. You want to give us something?
Well, yeah, so that's exactly why when we talked earlier, we talked about the Noble's TCPA wireless compliance solution, that we specifically funnel the agent through a PBX that doesn't have the capacity to store numbers or to randomly or sequentially dial numbers, that basically cannot operate without human intervention. So by forcing the agent to pick up the phone and manually dial the number, but still have the ability for that PBX to then do a compliance check to see if the call is in compliance with various regulations, and we still believe that the solution is capable of meeting that definition. So again, the agent would be calling on a PBX versus on the actual dialer.
Okay.
Now, the dialer does have the capacity to do manual dialing and preview dialing and all the predictive dialing capabilities that we've talked about here, and so for calls that are appropriate for that, we can still meet those needs. But for calls that cannot be made on an automated dialer platform, we have this compliance solution that allows you to, again, make the manual call but still be in compliance with all of the other rules that are out there.
Great. All right, so now here's an interesting question, I think, as well. It says, does express consent protect agencies? If cell number is provided at a time of service as a contact number, and this information is transferred to an agency, is this express consent, considered express consent? And I think that's funny. I was at a location recently, and that's exactly the prerogative they're going under. That, hey, we as the agency kind of get consent because our client received it. Is that a true statement, I guess?
Let's talk about that. FCC ruling 2008 came out with respect to the debt collection industry, saying in short, debt collection industry, if you are calling on behalf of a creditor and if that creditor obtained consent to call the number voluntarily, either in writing or orally, then you calling on their behalf sort of step into the shoes of the creditor. It's as if the creditor themselves made the call and you have expressed consent to make that call. What is happening right now, and many of you know because you heard of this Mays decision, that consent FCC ruling is literally being challenged right now in the 11th Circuit Court of Appeals. That was an initial Florida decision. Now it's gone to the Federal Court of Appeals level, and that judge's decision is being challenged. He basically said that, wait a second, I think that this FCC ruling is not express consent under the statute. It's implied consent. It's improper. But that's only one district court in one state of Florida. Yes, it is going to the 11th Circuit. No ruling has been issued, but most courts throughout the United States so far have looked at the FCC consent ruling and said, if you, debt collector, are collecting on behalf of a creditor and you get that number and you can prove that it was voluntarily given to the creditor in the first place, then you have a consent to call. I know people have questions. Well, does that also apply to the healthcare industry, so that a hospital has their debt collection agency collect on their behalf and they got the number voluntarily in the first place? Does the debt collector now have consent because the hospital got it in the first place? The Mays Court is challenging that issue. Various courts have held that that also falls within the purview of that 2008 ruling. But that issue is being challenged. And how far does that consent go? In other words, if the hospital got consent, but then some independent contractor of the hospital turns out to be the creditor, and that independent contractor then gives their debt collector the telephone number, says, hey, collect on my behalf, and I got this number from the hospital. Does the hospital's original consent to call also then transfer to the independent contractor, who then transfers it to their debt collection agency? Very, very tough and complicated questions, and that's another discussion. But general consent, as I applied it, if you got the number from your creditor, you should be able to call if you're collecting on their behalf.
So you kind of touched on this in your answer, and another question was, is there anything like implied consent? And if so, how is it defined?
So there is, but basically the TCPA statute says you have to get express consent. And express consent as a specific definition under just plain ordinary dictionary meaning, and that's how courts usually will interpret words in a statute. They'll say, hey, there's no specific definition, but we can look to the common ordinary dictionary definition. So they're going to look at what express means, and express means such as, it means direct, given unequivocally and absolutely. So the question is going to be, well, if someone gave their consent directly to the creditor, does that transfer over to the debt collector? If the debt collector is truly deemed an agent and if they literally step into the shoes of the creditor, maybe. But this issue of this implied consent versus express consent is being challenged right now in the Mays decision in the 11th Circuit.
Okay, so it's all tied together. I get that.
It is.
All right. So we've got a few minutes left, and I've got a few more questions here coming in. So David and Howard, we'll get through as many as we can in the time allowed. Kind of the next question really was, maybe you sparked some interest in the whole regulatory and in the legal discussion. So the question is, do you foresee further regulation changes on the horizon? That's kind of an open-ended question. So I'll give both of you guys have a chance on that one.
Well, this is David speaking. That is the question of the hour. There are numerous petitions right now from numerous different groups that are asking the FCC to reconsider their expensive dialer definitions, because what everybody says is that the FCC, you looked at the dialer definition in the TCPA and you were so concerned that people were trying to get around that definition by yanking out those random and sequential number generators that you went too far and you expanded the TCPA's definition. So now that you're deeming that any predictive dialer is a dialer under the TCPA, and that anything that can dial without human intervention, well, what is that? Anything today can dial without human intervention, and I venture to say that once I get a call, or once I am sued by one of my friends because I had his number in my cell phone, and I somehow automatically dialed that cell phone call to him, and he sues me into the TCPA, trust me, the FCC is going to get involved. But the FCC is getting involved right now. They understand that they need change. I have met directly with the FCC in April 2013 in a face-to-face meeting with many of the persons who are literally responsible for TCPA policy. And they understand that the new rules are hurting businesses, that businesses are closing as a result of these new draconian rules, that companies are shipping off their calling and dialing centers overseas in order to manage and, to come within and fall within the purview of compliance with the new and older rules. And this is a very, very, very big problem. The FCC understands that they're killing American businesses by these rules. So changes on the horizon, but they are being very, very cautious. There are numerous petitions before them, and I believe that some of these petitions, at least in their mind, they may consider could go too far, so they're very concerned of unintended consequences and opening the floodgates for everyone in the world to start using their dialers if they should grant the petitions that are currently pending. Many of the petitions are excellent and well drafted. It's just that the FCC is very, very cautious about what they're going to do. I'm working with some persons on a new petition that should be filed hopefully shortly to make changes because there needs to be a workaround, and there's some impossible rules that the FCC didn't foresee would be happening as a result of some of the case law coming down on the FCC interpretation, such as wrong number calls. How do you defend yourself against that perfectly? Very, very difficult issue. So that's what I see so far.
I see. Kind of more getting down to more of a tactical question, and I think it's something that I've heard many people ask me, and I would love to hear both your guys' opinions on this. And the question is, how do I handle phone number portability as it relates to time zones and calling windows? And of course, landlines, who used to be landlines, that now become cell phones. So it's kind of an all-encompassing question, but it's really around phone number portability. So
it is, and that is it is a difficult question. There is a sort of a weak, but nevertheless an exception under the Code of Federal Regulations with respect to ported numbers. Let me just be very clear. Call forwarding, meaning someone who forwards their number to a cell phone, does not create a TCPA claim. Yes, you could leave a pre-recorded message and have potential liability for leaving that on the landline, but if you forward your landline to a cell phone number because you want to forward it for that day or whatever, you don't create a TCPA claim and all of a sudden a cell phone claim as a result thereof. But a ported number is when the number is literally changed from a landline to a wireless line. Therefore, the FCC gives basically a 15-day exception for numbers that are ported. They call it their safe harbor. It's the only safe harbor that I'm aware of in the TCPA at all. And they say, look, if a number is ported on January 1st, you have until January 15th to make sure you're scrubbing to determine that that number is no longer a landline number. And once it's no longer a landline number and you've scrubbed it, then you're able to, quote, gauge your potential liability because you can figure out basically that you're calling a cell phone. Of course, the time zone issue could be a problem because you don't know when you're calling that number or what time zone it is, and that could be a potential problem. But that can be figured out by numerous other methods, which too lengthy to go into here, but that's my comments on ported numbers.
Okay, I'm going to ask one last question. I think we're running out of time, and I think this is an interesting one. It says regulations on calling a patient's employment phone number. So not quite the TCPA issue with dialing, but it was an interesting question that was posed by one of our attendees.
Well, that seems to be, and I'm not sure I completely understand the question, but as I see it, sort of, if you know regulations on, did you say calling a patient's employment phone number? Yeah, my assumption is it's collections. It's a collections call that right. I work for XYZ company. You're calling me at work and trying to collect money for healthcare. That's a good question. Putting on my FDCPA hat for a second, if you're calling someone's employment phone number, as long as you know there's not a prohibition to call that number, or once the person says to you, do not call my employee, or if the employer themselves says, do not call this number again, you need to honor that. But generally, you don't have a harassment claim for calling someone on their employment phone as long as you either, until such time as you're told that you're not allowed to call it, and to avoid, of course, any excessive calls to that number. Okay. Documented to make sure that you stop calling the moment someone or the employer tells you not to call it. Got it. So, Howard, David, you can take a breather here for a minute or two. As we're wrapping this up, I wanted to give you any chance to comment on anything that as we were going through, or any comment that maybe we kind of skipped over and you kind of had a second thought you wanted to bring up for all the people on the line today.
Yeah, well, I'd like to just briefly revisit the question about the time zone and calling windows.
Perfect.
One of the things that we, of course, and David said this very well and eloquently, that you need to scrub your records regularly. And you can do that through the subscription services through like Possible Now, for example, or a real-time wireless list management solution on your dialing platform. So we can help with those types of situations. Where once you've identified that this is in fact a wireless number, or the fact that the number has been ported, you know, you can also have in a record you would have their address. So perhaps you subscribe to someone like Targus Info, where you can get authoritative lists of name and address changes through the postal system. Once you have both the phone number, the area code and exchange, plus the zip code, the Noble system can actually triangulate the most conservative calling window for that particular situation, so that you don't call too early. Let's say it's a Seattle number. You don't want to call you know, before 9 o'clock Pacific time for the Seattle number, but you don't want to call after 8 or 9 o'clock if they've moved to Massachusetts, so to Boston. So we can help narrow that down to the most conservative window, and we call it a safe harbor window, if you will, that takes into account both the phone number and the zip code.
Yes. All right. Thank you, Howard. David, once again, any closing comments you'd like to make to everyone on the call?
No, I understand the difficulty for all of you, especially you telemarketers out there, how it is to comply with the new written consent rules. And I understand that the FCC thought they were giving you a gift by saying that you can also, you know, obtain consent via the e-Sign Act. But I understand how difficult it is to obtain consent in that regard. There is a petition, I believe, that has just been filed recently where they're asking the FCC to rule that those who have obtained written consent in the past, even though it was not written consent in the context of how the October 16, 2013 written consent rules require, to please grandfather in all of those written consents so that new written consents that are strictly compliant with the October 16th rules do not have to be obtained, because as someone said, you have 450,000 numbers that you have written consent for. Do all of a sudden they now have to get written consent again under the new October 16th rules with all the new disclosures that are required? Hopefully the FCC will see reason and vision and grant this petition and grandfather in all of those calls. But the key is right now compliance. Unfortunately, until we get absolute definitive case interpretations or FCC reversal of some of its prior opinions regard to what is a dialer, what is the scope of a dialer, we're going to be facing having to comply with these rules. Again, many states are taking those FCC rules on dialer pronouncements and taking them lock, stock, and barrel and saying, this is what the FCC says. You have a predictive dialer. You have a dialer that falls into the purview of the TCPA. So compliance, unfortunately, or fortunately for all of you who can do it, is the key today, because you have to manage your dialers, you have to manage consent, you have to manage your workarounds, et cetera, and scrub, scrub, scrub. Thank you so much for at least this opportunity of giving me the time to speak to all of you today. I know we flooded you with so much information on the informational side, the collection side, the telemarketing side.
Well, David, I want to first off thank you. We loved your insight. You provided a lot of interesting thoughts that in some areas that I think is going to surprise me in a good way, so that's all great. Also, on behalf of Noble and myself, Henry Dancer, I'd like to thank everyone who participated on the call today. I think it shows how important this topic is and how many questions we've received, and all up to the last minute. We keep receiving more and more questions, and quite frankly, we have kind of run out of time and don't have time to answer them all. But we will answer them by email, and we are going to work on scheduling a second call in the next few weeks. Hopefully some of the things that David talked about that are in flux right now will get a little bit more clear, and we can take that out. I think this is an ongoing process. I enjoyed it. I learned something from it, and that's my goal for everyone on the call. If you each walk away with at least that one nugget of information that will help you in your business, I think we can consider this hour successful. Also, since there were a lot of nuggets in there, we are going to be the call was recorded, and it'll be a few days, but we will send for all the people who registered a link to the recording, so you can re-listen to it and maybe catch a few more nuggets of things. So once again, thank you everyone for joining. I appreciate the questions and the insight, and have a good day, and we will talk to you again soon. Bye-bye.
Thank you. This does conclude today's conference call. You may now disconnect. Presenters, please hold the line.